236780, charged with aggravated child abuse. I'm going to appoint the public defender to represent you. I reviewed the probable cause affidavit. I do find probable cause exists. Does the state wish to be heard as to bond?
I spoke to PTR before, and because of the charge, it does not qualify for PTR, so no objection to a $1,000 bond. To comply with whatever DCF plans there are, so if it's no contact with the victim, then it's no contact, but if DCF has a plan to allow her to have contact with the minor child, then no objection.
All right, thank you. I appreciate that from the state, but I'm not inclined to do that at this time, ma'am. Your bond is $5,000. You're not allowed to have any contact with the minor child. I will order that you comply with whatever DCF recommends.
Your Honor, we would add that she has no criminal history and is employed full-time. And because of that, we would just ask that we keep the $1,000 bond that the state has suggested.
Your early approach.
Yes. I apologize for that really loud sound. I tried to turn it down a little bit. It's a new system for the courtroom, so we're getting used to that. All right, based on the representations by counsel, I will reduce your bond to $1,000. You're still not allowed to have contact with the minor child. I'll order that you comply with any recommendations by DCF. What says the state as to maintaining a separate residence?
That's why state requested to comply with whatever DCF's plan is. I don't know what the plan is and if there will be a long-term plan, so whatever, we just want her to comply with whatever that is, because they will have a case manager assigned to this case.
All right, so at this time, I'm going to order that you maintain a separate residence, but if the DCF case plan comes back and they recommend that you're allowed to live with the minor child, then the court will allow you to do that in compliance with the DCF plan. Do you understand?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. Good luck.
Your Honor, we would just ask that she be allowed to have a weapon only because she's a correctional officer.
We have no objection to, while she's present at work, to have a weapon, but she cannot have a weapon or firearm when she leaves the confines of her job or employment.
Is that possible for her to leave the weapon at work?
Yes.
All right, then I'll allow that you can have a weapon only as it relates to your job. You're not allowed to take it off the premises. You can't have a weapon at home. Do you understand? All right.
It's about.
Yes, sir.
May we approach off the record, Your Honor?
Yes.
Not on the record, but not by you.
Do you need the sound or no?
No, just off.
All right, that's case number 21MM1407. I'll appoint the public defender to represent him. Counselor, there's probable cause in this case. Does the state wish to be heard as to bond? I'm setting the bond at $5,000 based on his criminal history as well as the facts of the case. He's not allowed to have any contact with the victim. That includes electronic, third party, any kind of contact at all. He's not allowed to possess a weapon of any kind, firearm or ammunition, or be within 1,000 feet of the victim. Please tell me your name.
Bradley Walter McEwen Tharp.
Sir, you're here in case number 21MM1402AO, charged with battery, domestic violence. Sir, I reviewed the probable cause affidavit. There is probable cause in this case. I'll appoint the public defender to represent you. Your bond is $500. You're not allowed to have any contact with the victim. I'll order that you maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings if you need that. Do you need that?
Nope.
No? Then I'll not allow that. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Anything else the state would request?
No, Your Honor.
All right, good luck, sir. Please tell me your name. You're here in case number 21MM1381AO, charged with battery domestic violence. There is probable cause. I'll appoint the public defender's office to represent you. Your bond is $500. You're not allowed to have any contact with the victim. That includes electronic communication as well as third party. Do you understand? I'll order that you maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Your Honor, he does qualify for pretrial release.
All right, because you qualify, I'll place you on pretrial release with all of the same conditions. You understand that? You understand? You have to answer out loud.
Yes.
All right, good luck, sir.
Christian law is mental health.
There is no objection to ROR, Your Honor.
All right, this is 21MO257. I'm going to appoint the public defender's office.
We'll waive, Your Honor.
All right, thank you, counselor. I will authorize a release on her own recognizance on all 3 counts with special conditions that she cannot return to this scene. Please tell me your name.
Ryan Blake.
Oh, counselor, if you'd like to put your appearance on the record.
Yes, good morning. Alicia Adamson for the record, representing Brian Blake.
All right, this is case number 21 CF 1469AO. Sir, a capias was issued for your arrest for tampering with a witness to hinder communication to law enforcement officer, domestic battery by strangulation, and battery. The bond amounts are $2,500 on count 1, $150 on count 2, and $100 on count 3. You're not allowed to have any contact with the victim, co-defendant, or witnesses in the case. You're not allowed to return to the scene of the offense, and I'll order that you're not allowed to possess a weapon of any kind, firearm, or ammunition.
Your Honor, to resolve 2020 CT 5985, the offer of the withhold of credit for time.
Your Honor, I've already gone over a plea form with my client. I explained all of the rights. I have a signed plea form with the withhold court costs, credit time served.
As to the reckless driving charge?
Yes, it's 2020 CT 5985AO.
All right, sir, raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Sir, your attorney just told this court that you'd like to enter a plea to the charge of reckless driving. Is that the case?
Yes, ma'am.
All right, counselor, can you approach with that?
Yes, Judge.
Thank you. So your attorney just handed me what looks like a plea form with your signature. Is that your signature?
Yes, ma'am.
So you understand all the rights you're giving up by entering this plea?
Yes, ma'am.
You understand that if you're on probation, this plea could violate that probation?
Yes, ma'am.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am.
All right, then at this time, how do you wish to plead to the charge of reckless driving?
No contest, ma'am.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, order you to pay court costs. I'll give you a year to pay those court costs, and I'll order that you serve
1 day.
1 day in jail and give you credit for the 1 day that you've served. All right, good luck, sir.
Yes, ma'am.
Thank you, counselor. Please tell me your name. What's your name, sir? Oh, you don't speak English. Hold on. Oh. Okay, so now we have interpreter cases? Oh, wait, was I not supposed to do it using this?
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Good morning, ma'am. Thank you very much. He's putting on the headset now, if you can connect to the headset.
Just one moment. He can hear the interpreter.
All right, please tell me your name, sir.
Ilmar Adolfo Miranda Agosto.
All right, sir, you're here in case number 21 CT 159 and 21 CT 160. You're charged with operating a motor vehicle without a valid driver's license and driving under the influence with a blood alcohol level of 0.15 or higher, or with a person under 18 in the vehicle. I'm going to appoint the public defender to represent you. I do find probable cause exists. Your bond is $500 on the DUI and $100 on the no valid driver's license charge. You're not allowed to drive without a valid driver's license. Do you understand?
Yes.
You're not allowed to possess or consume any alcoholic beverages. Are there any other conditions the state would request? All right, good luck, sir.
Thank you.
100, yes. Please tell me your name.
Joel Hernandez Sierra.
Joel Hernandez Sierra.
Yes.
All right, sir, you have a warrant that was issued for your arrest in case number 21 CF 1040 for grand theft of a motor vehicle. Your bond is $5,000. You're not allowed to return to the scene or have any contact with any victims or witnesses in the case, and I'll appoint the public defender to represent you. Good luck, sir.
¿Podría preguntar algo?
May I ask?
Yes.
Ya, fue que yo alquilé un carro en el aeropuerto. Entonces,
It's because I rented a vehicle.
Don't talk about can you please advise him not to talk about the facts of the case?
So, sir, we're not having an evidentiary hearing today. I'm just advising you what the charges are and what your bond is. You want to have that discussion with your attorney, who can file any motions they think are necessary in front of the trial judge.
ok, gracias.
All right, good luck.
Okay, thank you.
Please tell me your name.
Verónica Román.
Veronica Roman.
You're here in case number 21 CF 2356AO, charged with possession of oxycodone and retail petty theft. I'm going to appoint the public defender's office to represent you. I do find probable cause exists in this case. Your bond is $1,000 on count 1, $100 on count 2. You're not allowed to return to this scene. You're not allowed to possess or consume any illegal substances. As to your 2 out on bond cases, 20 MM 171AW, oh, sorry, it's just one case. I'm inclined to revoke her bond, counselor, unless you have any argument as to why the court shouldn't.
Your Honor, I would just argue that it is a nonviolent offense.
She accepted pretrial version in January. Obviously, this will kick her out of pretrial version, but. And I don't know if she started to complete parts of the program.
Doesn't, doesn't appear the program's working. All right, at this time, I'll take no action on your case, your out on bond case. Good luck. Oh, we don't have any other interpreter cases. Thank you for your time.
Thank you, Your Honor. Have a great day.
You as well. Please tell me your name.
Ripley Thea Andrews.
All right, you're here in case number 21 CF 2234, charged with aggravated assault, domestic violence. There is probable cause. I'm going to appoint the public defender's office to represent you. Your bond is $5,000. You're not allowed to have any contact with the victim. I'll order that you maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
All right, good luck, ma'am. Oh, wait. Oh, I did miss that. Oh, I'm gonna take no action on the out on bond case. She doesn't have to come back. Her attorney can explain it. I didn't revoke it. I'm sorry, Miss George. I'm sorry, Dexter. The clerk caught me. Please tell me your name, sir.
James Bell, ma'am.
All right, sir, you're here in case number 21 CF 111AO. A warrant was issued for your arrest for false imprisonment and battery dating violence. So there is probable cause. It was already found by a judge. Your bond is $1,500 on count 1. It'll be $100 on count 2. You're not allowed to have any contact with the victim. You understand what no contact means?
Yes, ma'am.
All right. You're not allowed to return to this scene. Were you living together?
Yeah, we're still living together.
Not at this time. I'm going to order that you maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't live there right now.
That's my plea.
I'm ordering that you maintain a separate residence. So if she's there, you can't be there.
Yes, ma'am.
All right, and your attorney can file a motion in front of the trial judge to modify that order, but for this time, you can't. And you can't possess a weapon of any kind, firearm, or ammunition. You understand? You can't have any firearms or any weapons.
No, ma'am.
All right, good luck, sir. Please tell me your name.
Melquiades Joel Cruz Melendez.
I have your last name as Cruz.
Cruz Melendez.
Okay, all right. You're here in case number 1500850, a violation of probation from out of county. There's no bond on that. I'll appoint the public defender's office to represent you. 21 CF 2365AO. You're charged with aggravated child abuse, 2 counts of battery, domestic violence. I'm going to appoint the public defender to represent you. Your bond, I'm sorry?
What does that mean? I'm sorry.
I couldn't hear you.
You
You have to get really close to the microphone. Leave your mask on.
said you're gonna represent who?
The public defender's office will represent you.
Oh, okay.
Yeah, I can't hear him at all. All right. I'm appointing an attorney to represent you.
Okay.
Your bond is $5,000 on count 1, $100 on count 2, $100 on count 3. You're not allowed to have any contact with any of the victims or witnesses in this case. Do you understand what no contact means?
Yes, ma'am.
You're also not allowed to return. I'll order that you maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, and you're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Frederick Howard, man.
Thank you, sir. You're here in 21 CF 2368AO, charged with battery, domestic, by strangulation, and aggravated assault with a deadly weapon, domestic violence. I'm appointing the public defender's office to represent you, sir. I reviewed the probable cause affidavit. There is probable cause in this case. Your bond will be $5,000 on count 1, $150 on count 2. You're not allowed to have any contact with the victims or witnesses in this case. Do you understand what no contact means?
Yes, ma'am.
All right, I'm going to order that you maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings if you need it. You're not allowed to possess a weapon of any kind, firearm, or ammunition. And sir, my paperwork says that you're a sex offender or a sexual predator. So I have to advise you that you still have to maintain those reporting requirements. You understand?
Yes, ma'am.
All right, good luck, sir.
You see the line?
Right here.
Please tell me your name, sir. What's your name? All right, sir, you're here in 21 CF 235280, charged with battery and burglary of an unoccupied dwelling. I'm going to appoint the public defender's office to represent you. Sir, I reviewed the probable cause affidavit. There is probable cause in this case. Your bond will be $100 on count one, $5,000 on count two. You're not allowed to have any contact with the victims in this case. Do you understand what no contact means? You're not allowed to return here for any reason except one time with law enforcement to gather your belongings. Do you understand? You're not allowed to possess a weapon of any kind, firearm, or ammunition. Good luck, sir.
Have a good weekend, everybody.
Have a good one. Please tell me your name.
Olizio.
All right, sir, you're here in case number 21 CF 1876. A warrant was issued for your arrest for battery by strangulation, domestic, and battery, domestic. So another judge has already found probable cause. Your bond will be $5,000 on count one, $100 on count two. You're not allowed to have any contact with the victim. I'll order that you maintain a separate residence. You're not allowed to possess a weapon of any kind, firearm, or ammunition. And sir, you understand what no contact means?
Yes, ma'am.
All right, good luck.
Your Honor, we would ask, is there any possibility you will be lowering the bond amount only because he only has one misdemeanor, no violent history?
He does qualify for pretrial
How,
release.
how does that qualify for pretrial release?
I'm sorry.
How does that charge qualify for pretrial release?
It does according to our admin order, Your Honor.
It's not a PBL, it's not a light felony. It's an F3.
Again, he doesn't have a history of violence, Your Honor, so we would just ask.
What says the state?
No, no objection, Your Honor.
All right, at this time, I will place you on pretrial release with all of the same conditions. You understand the conditions?
No.
And no contact means no electronic communication, no third party, nothing. You understand? All right, good luck, sir. Please tell me your name.
Mark Wright Pyramid Jr., ma'am.
Sir, a capias was issued for your arrest in case number 20 CF 5185 for failing to appear for arraignment on a charge of possession of methamphetamine and possession of drug paraphernalia. The bond on that is $5,000 on count one and ROR on count two.
All right.
In case number 21 CF 1877, a warrant was issued for your arrest for domestic battery by strangulation, false imprisonment, tampering with a witness, and petty theft. I'm going to appoint the public defender's office to represent you in both cases. Your bond on count one is $5,000, count two is $5,000, count three is $2,500, count four is $1,000. You're not allowed to have any contact with the victim. You understand what no contact means?
Yes, ma'am.
You're not allowed to return. I'll order that you maintain a separate residence. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Ma'am.
All right, good luck, sir. Please tell me your name.
Rafta Pierre Lewis.
All right, you're here in case number 21 CF 1978AO. A warrant was issued for your arrest for battery, dating violence, and domestic battery by strangulation. Sir, do you want to speak?
Yeah.
Leave your mask on.
Okay.
Hold on, let me have you raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Isaiah Barnes.
You can put your hand down, sir. Does the state wish to inquire?
Yes, Your Honor. How do you know Ms. Eluding?
That's my girlfriend.
Are you afraid of her?
No, ma'am.
Would you like for her to be allowed to have no hostile or non-violent contact with you while this case is pending?
Yes, ma'am.
Do you two live together?
Yes, ma'am.
Would you like her to be allowed to continue to live with you while this case is pending?
Yes, ma'am.
Were drugs or alcohol related to this case?
No, ma'am.
If something happened in the future, would you feel comfortable in calling the police or 911?
Yes, ma'am.
No further questions.
I'm appointing the public defender's office. Does the defense wish to inquire?
No questions, Your Honor.
Let me say that a second.
Yes. All right, as to case number 21 CF 1978AO. Wait. Sir, you said that you were living together?
Yes, ma'am.
Does anyone else live in that residence?
Yes, ma'am.
Who?
Just my grandmother, and that's it.
Whose house is it?
It's my grandmother's house.
All right. Then in case number 21 CF 1978AO, I will allow you to have peaceful contact. Ma'am, do you understand what peaceful contact means?
No cursing, no.
Right, you can't even raise your voice at Mr. Barnes.
Okay, no problem.
Do you understand?
Can I make an argument?
Yes?
The issue state has is, so on the 1879 case, he is the victim in that burglary of dwelling with assault or battery therein. State's not going to request that she be held at no bond. State's going to request she gets bond. However, we believe based on these two incidents and their close in timeliness that they should have no contact, at least while these cases are pending, and let the trial division decide if they maintain a separate residence. Excuse me, I understand that the victim of both cases is present and says he's not afraid and he wants contact. However, we have two incidences short in time where he's called the police and been very upset. So state's argument would be that they just need time to be apart right now.
All right, does the defense have any argument?
No, ma'am.
We would just echo what the state has just said. We would ask for a bond in this case. And no objection to the no contact for now, Your Honor.
All right, I'm going to order that you're not allowed to have any contact. That means you can't call him on the phone, you can't contact him through social media or send a message through a friend. Do you understand?
Yes, ma'am.
All right. You're also not allowed to return to that residence for any reason. Do you understand that?
Yes.
And in case number 21 CF 1879, it's another warrant, so probable cause has already been found. I'll appoint the public defender's office. I understand the parties are requesting a bond. I'm not inclined to set bond on count one at this time.
Your Honor, we would just argue that it's not a situation where she broke into a random house and committed an offense. This is a situation where they actually have a relationship together, and that would be the only reason why we would ask that you set a bond in this case.
He's not the only person who lives at the residence, however. So the court, I'm sorry?
He's the only alleged victim in the case, though. I understand that it states it in the affidavit to issue warrant in that case that his grandmother lives there, but
Right.
and he is the only victim of that.
And if you, correct.
It's her house, so she's a victim of the burglary. He's a victim of the battery.
And if you,
So not hearing from her,
and if you look, Your Honor, at the fact that she does not have a criminal history, it's not like she has a long history of violence, we would just ask that you set a bond.
Does the court have discretion to set bond on punishable by life offenses? All right, so in case number 21 CF 1978, your bond is $5,000 on count one, $100 on count two, no contact, no weapons of any kind. You're not allowed to return to that residence. In case number 21 CF 1879AO, your bond is $15,000 on count one, $100 on count two. You're not allowed to have any contact with the victim. You're not allowed to return to the residence. You're not allowed to have any contact with his grandmother. You're not allowed to possess a weapon of any kind, a firearm or ammunition. Do you understand?
Yes, ma'am.
Good luck. Thank you, sir.
No problem.
$15,000 on
Seven on the burglary of a dwelling with a battery. So that's. Yes, 7-9. Nope, 7-8. Yeah, 7-9. Here it is. Yes, 7-9.
Judge, on Michael Roach,
Yes.
victims were told he was not going to be allowed to come to court. Is this Mr. Roach?
Yes.
The victims were told he was in COVID restrictions and we're not going to be able to come to court. I got a text message from security downstairs, but they were present. So I don't know who told them that. I was up here in court. They get a text message saying, but they were present downstairs. I don't know what their pleasure was as far as contact or no contact. But I have victim Caitlin Hutchinson was present, and then Montarius Burton and Delania Loman. The three people that were present downstairs.
And they're gone now?
And they're gone now. They gave me their numbers, but they're not present. So I don't know how that was communicated to them, but I wanted to at least inform the court that they were present
Yeah.
downstairs.
Did it tell you what time they were here?
I got the text message at 9:13.
So they're probably gone. All right, this is case number 21 CF 2370. Sir, you're charged with battery, domestic battery by strangulation. I'm going to appoint the public defender's office to represent you. Did you have an argument?
In this case, my client was charged with battery by strangulation. And in the case, if we go to the four corners of the arrest affidavit, it states that the victim did not admit to being strangled when she spoke with the police. She stated that her scratches came from her passing out due to being drunk and falling in the bushes. You have my client stating that he never strangled or choked the victim. And then you have a witness who stated she never witnessed any strangulation, only that allegedly the victim told her that she was strangled. And because of that, we would say there's no PC for a battery by strangulation. In this case, there is no evidence of bruising around the neck. The only scratches she had were on her left arm.
Does the state have any argument?
State does not, Your Honor.
Counselor, I appreciate your argument, but I think that the eyewitness statement is enough for PC. I'm not suggesting it's enough to get past reasonable doubt, but I think it's enough to establish probable cause.
Your Honor, we would argue not when she did not witness the incident. There's no one witnessing the actual strangulation, and you have a victim saying that she was not even strangled.
Right, but the excited utterance that she made to the eyewitness is, he choked me and I passed out. So that excited utterance, I think, is enough for probable cause. I think you have a great argument for beyond all reasonable doubt. without the witness testifying. Lots of other things. So I am finding probable cause,
No objection to PTR.
but he qualifies for pretrial release. I'll place him on pretrial release. Sir, you're not allowed to have any contact with the victim or any witnesses in this case. Do you understand what no contact means?
Yes.
You can't call them on the phone, no contact through social media. You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to possess or consume any alcohol, and you'll be subject to random screens while you're on pretrial release. Do you understand?
Yes.
All right, good luck, sir.
And Your Honor, will you allow him to return back out of state? He stays.
Where do you live?
Pennsylvania.
Yes, I'll allow him to return to Pennsylvania. Good luck.
Your Honor, Ayala, his behavior.
Hold on, I don't have that one next.
He did that one.
I have Burton. Is that your name, sir? What's your full name? You're here in case number 21MM137380, charged with battery domestic violence. I'll appoint the Public Defender's Office to represent you. There is probable cause in this case. How does this qualify for pretrial release?
I don't commend that, but I'm guessing just based off the charge,
But,
the criminal history, I don't.
right, he has a felony battery conviction in 2020.
Your Honor, we would just ask that a monetary bond is set.
All right, your bond is $500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
All right, I'll order that you maintain a separate residence. I will allow one-time return with law enforcement to gather your belongings. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand? All right, good luck, sir. Please tell me your name.
Terry Byerly.
You're here in case number 20MM356680, charged with, a capias was issued for your arrest for failing to appear for trial on a charge of battery domestic violence. The bond is $2,000, and you're not allowed to have any contact with the victim. I'll appoint the Public Defender's Office. Good luck. I have Ian Aberaj bonded. What's your name?
My name is Jonathan Bishop.
All right, sir, you're here in case number 21-65962, charged with driving under the influence. That's not right. Hold on, it's 21 CT 1561.
Yeah, I think so.
You're charged with DUI, property damage, or personal injury. I'm going to appoint the Public Defender's Office to represent you. I do find probable cause exists in this case. Your bond is $1,000. You're not allowed to drive without a valid driver's license. You're not allowed to possess or consume any alcoholic beverages.
Your Honor, if you want to do bond or PTR, he was never interviewed and he has no criminal history.
Yes, that's exactly what I was going to argue.
I'll place him on pretrial release if he qualifies, but with a bond. It's going to be a $500 bond, and if he doesn't qualify, it's a $1,000 bond. No, I'll leave it at $500. It can be the same monetary. Sir, you're not allowed to possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. Do you understand?
Yes, ma'am.
All right, good luck.
Appreciate it.
No, 500. Pretrial release or just 500? I have Gonzalez bonded. Yes. Yeah, no. Or 500. If he doesn't qualify for pretrial release, they won't put him on it, but no matter what, his bond is 500. Both ways. I have Eugene Rios Diaz. All right, this is case number 20 CT 7293. A capias was issued for failing to appear on a driving while license suspended, $500 bond. I'll appoint the public defender's office to represent him. He was medical. That didn't work out. Okay, thank you. Yes, sir. Sir, please tell me your name.
Barry Moses.
Sir, a capias was issued for your arrest in 21 MO 12880 for failing to appear for arraignment on a charge of open container on public property. Let me ask, does the state have an offer?
I have the city withhold credit for time served, $223 court cost and a $10 filing fee.
Sir, are you interested in accepting that offer?
Yes, ma'am.
All right. Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
Yes, ma'am.
Sir, you understand, you can put your hand down now. You understand that if you enter a plea of guilty or no contest this morning, you're going to be giving up your constitutional right to remain silent, your right to testify on your own behalf, your right to call witnesses and present any defenses you might have at a jury trial if one is required. If you enter a plea of guilty or no contest, you're going to give up those rights.
Yes, ma'am.
You understand if you're on probation, anywhere this plea could violate that probation?
Yes, ma'am.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am.
All right, sir. At this time, how do you wish to plead to the charge of open container of alcohol?
Guilty.
All right, I'll accept your plea of guilty. I find it's freely and voluntarily made. I'll withhold adjudication, order you to pay court costs, give you credit for
4 days.
4 days in jail. Sir, I'm going to give you a year to pay your court costs and the filing fee. Good luck, sir. Thank you.
Mrs. Johnson, Your Honor.
I don't want to spread nothing. I got open wounds.
All right, sir, tell me your name.
Ms. Johnson.
In case number 21MM1315, a warrant was issued for your arrest for criminal mischief. The bond on that is $500. I'll appoint the public defender's office to represent you.
Yes, ma'am.
In case number 21MM1372, you're charged with petty theft. I'm going to appoint the public defender's office to represent you in this one as well.
Oh,
Sir, I reviewed the probable cause affidavit. There's probable cause in this case. Your bond is $250. You're not allowed to have any contact with the victim. You're not allowed to return to this scene.
Yes, ma'am.
Does the state have any thoughts on his out on bond cases?
Oh, man.
He's out on bond for possession of drugs and,
No objection, no action, Your Honor, in the battery. No objection, no action, Your Honor.
all right. Sir, at this time, I'm going to take no action on your out on bond cases. Good luck. I'm not revoking your bond.
Okay.
So good luck, sir. Please tell me your name.
Corey Hall.
You're here in case number 21MO256, charged with disorderly conduct. Does the state have an offer?
Withhold credit time, sir.
Sir, are you interested in accepting that? Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Okay.
Did he say I do?
Oh, yeah.
All right, put your hand down, sir. You understand that if you enter a plea of guilty or no contest this morning, you're going to be waiving or giving up certain constitutional rights, like your right to remain silent, your right to testify on your own behalf, your right to call witnesses and have them testify on your behalf at a jury trial when one is required. You understand you're giving up those rights. You have to answer out loud.
Yeah.
You understand if you're on probation, this plea could violate that probation. You understand if you're not a United States citizen, this plea could subject you to deportation. And sir, are you under the influence of any substances that would impair your ability to understand what's happening today in court?
No.
All right, at this time, how do you wish to plead to the charge of disorderly conduct?
No contest.
I'm sorry?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for
2 days.
2 days in jail. Sir, I have to order that you pay court costs in this matter, and I'll give you a year to pay it. Good luck. Please tell me your name.
Gregory Sproul.
Sir, you're here in case number 21MO258, charged with possession and consumption of alcohol in public. Does the state have an offer?
Withhold credit time, sir.
Are you interested in accepting that, sir?
Yes.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, sir. You understand that if you enter a plea of guilty or no contest, you'll be giving up your right to remain silent, your right to testify on your own behalf, your right to call witnesses and testify at a trial when one is required. You understand you're giving up those rights.
Yes.
You understand that if you're on probation anywhere, this plea could violate that probation.
Yes.
You understand if you're not a United States citizen, this plea could subject you to deportation.
Yes.
All right, sir, at this time, how do you wish to plead to the charge of
No contest.
possession and consumption of alcohol in public?
Okay.
Sir, I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for,
Days.
how many? 1 day in jail. I'll order that you pay court costs, and I'll give you a year to pay it.
Yes.
Good luck, sir.
Mr. Sproul, I think you have 2 days credit.
I'm sorry, 2 days. I'm sorry, I thought you said 1.
It's okay.
Sir, please tell me your name.
Eric Allen, Eric Allen Sullivan.
All right, you're here, sir, in case number 20MM41769. A warrant was issued for your arrest out of Brevard County for failing to appear on a charge of petty theft. The bond on that is $500. We'll notify Brevard County that you're here in our jail so they can come get you, but you do have a bond on that offense. In case number, I'm sorry?
I didn't mean to interrupt you. Can I bond out from here before I go there, or do I have to go there first?
You can, you have a bond. So if you're able to post that bond, you can bond out. In case number 21MO259, you're charged with open container of an alcoholic beverage. Does the state have an offer?
Yes, sir, I withhold credit time, sir.
Are you interested in accepting that today?
Yes, ma'am.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you were here just a moment ago. You can put your hand down. When I explained to the other gentleman the rights that he's giving up by entering a plea today.
Yes,
Do you understand those rights?
Yes, ma'am.
Do you have any questions for the court about those rights?
The only question I got, is there any way I'm only facing petty theft from Brevard. Is there any way we can, like, come up with a deal with that too? So I can just get it all over with?
I don't have jurisdiction over that case, so I can't do that today.
There's no way I can get ROR'd on a petty theft?
I can't do that because it's a warrant that was signed by another judge in another county.
Yes, ma'am.
But like I said, we'll notify them that you're here. So if they want to come get you, they can, or if you want to bond out, you can do that,
How long do they have to come get me?
however long it takes.
All right, thank you.
COVID changed everything, as you know, so some jails are transporting more easily than others, but I believe Brevard is one that's transporting. Other than that, do you have any questions for me about the rights you're giving up?
No, ma'am.
At this time, how do you wish to plead to the charge of open container of alcohol?
No contest?
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for
2 days.
2 days in jail. I'll give you a year to pay your court costs. And at this time, I'm going to take no action on your out on bond case.
All right,
Good luck, sir.
thank you.
Please tell me your name.
Raymond Fountain.
All right, sir, you're here for allegedly violating probation by possessing, carrying, or owning a firearm, and by failing to live without violating any law by committing the offense of possession of a firearm or ammunition by a convicted felon. There's currently no bond authorized on that. I'll appoint the public defender's office to represent you. Good luck, sir. Please tell me your name.
Angelo McCoy.
In case 19 CF 3633, it's alleged that you violated your probation by committing a new law offense of aggravated assault with a firearm, possession of a firearm by a convicted delinquent, discharging a firearm in public, and tampering with a witness. So at this time, there's no bond on that charge. I'll appoint the public defender's office to represent you. Good luck.
Thank you.
Please tell me your name.
Robert Ramos.
Sir, in 19 CF 4302, you have a violation of probation alleging that you failed to report to your probation officer within 48 hours of release, and that you changed your residence without first procuring the consent of your probation officer. There's no bond authorized on that warrant, and I'm not going to change that at this time. I'll appoint the public defender's office to represent you. In 21 CF 234380, you're charged with possession of MDMA and possession of drug paraphernalia. There is probable cause. I'll appoint the public defender in that case as well. Your bond is $1,000 on count 1 and $100 on count 2. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
All right, good luck, sir. So this is Mr. Siefker. Can you call his attorney, please?
Thank you.
Let's see if we have any better luck today with the phone. Should I press it? This is Judge Gibson. Mr. Stewart?
Good morning, Your Honor.
Good morning. Welcome to court.
Thank you.
All right, I have your client here again today. Mr. Stiefker, you're here in case number 19 CF 13638AO. There's an affidavit with a warrant alleging that you violated your probation by committing a new law offense of felony battery. At this time, there is no bond authorized on that warrant. And I'll not appoint the public defender because you have Mr. Stewart representing you. Do you understand?
Saying?
You have a violation of probation. And Mr. Stewart, are you intending to represent your client on that charge as well?
Yes, Your Honor, and we're working with the state in front of Judge Laurent to address a bond motion in that court, Your Honor.
All right. So your attorney's working with the prosecution to set a hearing in front of the judge, the trial judge who's hearing these cases. So at this time, you have no bond, but he's filing a motion.
Okay.
All right?
Typically, how long do those take? Not sure. How long do those take? Motions?
I can't give you a date. That's up to your attorney, the state, and then getting it on the judge's calendar. So I have no idea. All right. Good luck, sir. Thank you, counselor, for appearing once again in court.
Have a good weekend, Judge. Stay safe.
You as well. Thank you. Please tell me your name.
Khalif Choshay Jr.
All right, sir, you're here in case number 20 CF 9566AO. A warrant was issued for violating your probation in that you failed to live and remain at liberty without violating any law. The allegation is that you committed the criminal offense of possession of MDMA. At this time, there's no bond authorized on that warrant. I'll appoint the public defender's office to represent you. Good luck, sir. Please tell me your name. All right, sir. You have a warrant out of Osceola County in case number 19 CF 4078. The warrant is for receiving money from a pawnbroker. That's the charge. I'm sorry, by false verification of ownership. The bond is $1,500. It says that they will extradite. We'll notify them that you're here, but you do have a bond in that case. So if you're able to post it, you can bond out.
Yeah, even though my parents tried to bond me out last night, but for some reason it said there was like some kind of hold.
Get closer to the microphone, please.
I spoke to my parents last night. They told me there was a bond. They tried to get me out, but there's like some kind of hold that wasn't letting me until I went to court. So
There may be something else that's holding you. You have a bond in that case. Can I have his paperwork back? The last one.
what if I bond out? I will be able to leave from here?
Yes, if there's nothing else holding you, then if you post that bond, you can leave from here. But I don't know if there's something else holding you.
This Osceola County, I have a hold for this. Like,
You have to get really close to the microphone.
I have a hold for like this Osceola County, even though there's a bond. I don't know why it's not.
Oh, there may be something else pending in Osceola County. So I don't know that.
Will they be able to extradite me within 3 days? Supposedly it's taking forever because of coronavirus.
Right, so coronavirus has changed everything. So we will notify Osceola County that you're here and they can come get you. Good luck. Please tell me your name.
Jamal Hoyer.
Sir, you're here in case number 2040CT. A warrant was issued for your arrest for failing to appear on a driving while license suspended charge. There's no bond authorized on that warrant right now out of Martin County. We'll notify Martin County that you're here and they can come get you. And I'm going to appoint the public defender's office.
That's it? I can't bond out? They just got to come get me?
Yes, they will come and get you. Good luck, sir. Please tell me your name, sir.
Hector Morales.
All right, sir. You're here in case number 16407CF. A warrant was issued for your arrest out of Seminole County. There's no bond authorized on that warrant for violation of probation for trafficking in stolen property. We will notify Seminole County that you're here, and I'm going to appoint the public defender's office to represent you. Good luck, sir.
Thank you.
All right. That's the last one I have. Is the state ready for 33 days?
Yes, Your Honor.
I have Melissa Brooks, 21 CF 184.
To be granted the state file notice of non-filing for the 33rd day.
Dylan Roberts, 21 CF 29.
Granted the state file notice of non-filing for the 33rd day.
Mark Nichols, 21 MM 473.
Deny the state file the information on 225.
Marvin Green Jr., 21 CF 721.
That should be granted the state file no information on 225.
James Summers, 21 MM 53 AW.
Granted the state file no information on 225.
Jeff Washington, 21 MM 640.
Granted the state file notice of non-filing for the 33rd day.
I'm sorry, did you say granted? Thank you. Sorry, I was trying to multitask and. What is this?
Give a clearance. Proceed.
Oh, yes. 21 CF 330.
Should be denied the state file information on 225.
Thank you. So the order, I don't have an appropriate order
Or proceed.
for, right,
That's a private attorney case. Your Honor.
it is.
Your J, reach out to the defendant.
Yeah, I'll have her do that, but the court minutes will reflect I'm denying that motion. All right, anything further this morning?
No, Your Honor.
All right, court will be in recess. Please tell me your name.
B-R-O-C-K Williamson.
I need you to get really close to the microphone.
B-R-O-C-K Williamson.
All right. You're here in case number 21 CF 234980, charged with written threats to kill or do bodily harm. I'm going to appoint the public defender's office to represent you. I reviewed the probable cause affidavit. I do find probable cause exists in this case. What says the state as to PTR? I'm not sure how this charge qualifies, but it says that it qualifies.
No objection.
Does the state have no criminal history?
Yes, sir, I still nothing. I don't even see any arrests.
All right, at this time, I'm going to place you on pretrial release. Special conditions are, you're not allowed to have contact with any witnesses in this case. Do you understand what no contact means?
Just could you clarify, just for clarity's sake?
No speaking, no telephones. You can't contact any of the witnesses through social media or any kind of electronic app. You can't use a telephone or computer, nothing.
Okay.
No contact.
For the communications?
I'm sorry?
Am I going to get a list of the people who I can't contact?
It's any witness in this case.
Okay.
Hold on, let me see if the state has, do you have a witness list that's easier to see than what I have?
I don't, but I'm asking the defense, they can just give a copy of the police report. I don't know that, I don't have like a concise, witness list where they're all listed.
I don't either, and I have, so
Your Honor, we'll get him a copy of the.
Jack Necht would be one. Oh, you can get a copy? All right. Your attorney will provide you a copy of a list of all the names of the people you're not allowed to contact while you're out on pretrial release.
Okay.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. Are there any other requests, any other conditions the state would request? All right, good luck. Please tell me your name.
Elderly Dormo.
All right, in case number 21MM1366AO, you're charged with possession of drug paraphernalia and resisting an officer without violence. I'm appointing the public defender's office to represent you. There is probable cause.
I didn't do an offer because of their competency issues. We look at the, I think, Alabama cases, they're all competency issue cases.
All right, at this time, I was intending to revoke those bonds. Are you asking me not to? All right. Sir, I'm going to take no action on your out-on-bond cases, and I'm going to appoint the public defender's office to represent you. Your bond in this case is $500 on count one and $100, I'm going to say $100 on each count. Yes, sir.
Can you send me to Aspire Hospital, please?
I'm sorry, what?
Can you send me to Aspire Hospital, please?
Oh, what will happen, I can't do that today. I don't have the jurisdiction to do that, but your attorney is going to file a motion in front of the trial judge who's handling all of your cases.
Your Honor, we get an ROR in this case. January 26, 2020, on all his cases, he sits here, and then they ROR him later on. We have possession of paraphernalia, which normally we would plea out today, and because of his competency issues, he would just sit here until the 33 days, and then he's released again, or until a motion is filed with the judge where he is released on his own recognizance.
Does the state have any objection to that? All right, so at this time, I'm going to release you on your own recognizance on these charges. I'll take no action on your out-of-bond cases, and the public defender's office is representing you, so they'll file any motions they need to in front of the trial courts.
I'll get released today? I'll get released today, right?
Yes, question will be released today, Your Honor.
Oh, yes, I'm so, I can't hear up here. Nothing. Please tell me your name.
Sarah Doyle.
You're here in case number 21MM1375, charged with battery and fraud. I'm appointing the public defender's office to represent you. There is probable cause. Your bond is $500 on count one, $100 on count two. You're not allowed to have contact with the victim. You're not allowed to return to 7-Eleven. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Any other conditions the state would request?
No, Your Honor.
Good luck.
Yeah.
Please tell me your name.
Cornelius Brothers.
All right, sir, you're here in case number 21MM1400, charged with trespass on property after warning. There is probable cause.
Adjudication, credit for time served, no return. Credit for 2 days.
Are you interested in accepting the state's offer?
Yes, I am.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yeah.
All right, sir, you can put your hand down. Thank you. Did you have a chance to review the plea agreement, or did you hear from the public defender before you came to court today about the rights that you're giving up by entering this plea today?
Yeah, I read the plea agreement.
All right, so you understand all those rights?
Yeah,
And sir, you understand that if you're on probation, this plea could violate your probation?
yeah, I understand.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yeah,
All right, at this time, how do you wish to plead to the charge of trespass on property after warning?
no contest.
All right, sir, I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, order you to serve 2 days in jail, give you credit for the 2 days that you've served. I'll order you to pay court costs, and I'll give you a year to pay them. Good luck, sir. Thank you. Please tell me your name.
Fredo Rivera Acosta.
What name?
Fredo Rivera Acosta.
I don't have that next. Hold on 1 second.
He's not ready.
All right.
Judge, after I'm so proud, can we recall the Roche case this morning?
I don't have that case, and I don't know if do you have him here? All right, so can you work on getting him here, and we'll continue to call cases, and we can address it later? All right, you said your name is Acosta, right?
Fredo Rivera
Right.
Acosta.
You're here in 21 MM 1388 AO, charged with retail petty theft. There is probable cause. Does the state have an offer?
No, Your Honor. No offer, Your Honor.
All right, there is probable cause. I'll appoint the public defender's office to represent you. Your bond is $250. You're not allowed to have contact with the victim or return to the scene. As to your 2 out on bond cases, I'll tell you, Counselor, I'm inclined to revoke those bonds. It's attempted carjacking and grand theft, and the new case is a theft. Do you have any argument as to why I shouldn't revoke?
No, Your Honor.
All right, I'm revoking his bonds on those 2 cases.
He has court next week on this case.
All right, he can address it with the trial judges. Good luck, sir. Please tell me your name.
There you go.
Yoash Errol?
You're here in case number 21MM39, charged with trespass in an occupied structure or a conveyance. There is probable cause. Does the state have an offer?
Yes, Your Honor. Adjudication, give credit for time served of 2 days, no return, and no action on the out on bond that has a plea date of March the 11th. I would have resolved it today, but we can't.
Your Honor, I did go over the form that you signed by,
Oh, that would be fantastic. For every single person? Ooh. I don't know if you should give them to me now. Do you mind? I'm just afraid I'm going to forget if you don't give them to me one for the right person. Please raise your right hand, sir.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, sir. Your attorney just handed me this form, and I'm appointing the public defender's office that has your name on it. Did you sign this form?
Yes, Your Honor.
And you understand the rights you're giving up by entering this plea today?
Yes, Your Honor.
You understand if you're on probation, this plea could violate that probation?
Yes, Your Honor.
You understand that if you're not a United States citizen, this plea could subject you to deportation?
Yes, Your Honor.
At this time, how do you wish to plead to the charge of trespass?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days that you've spent in jail, order you pay court costs. I'll give you a year to pay, and I'll also order that you're not allowed to return to the scene. Do you understand?
Yes, Your Honor.
All right, good luck, sir. Oh, and I'll take no action on your out-of-bond case. I'm not revoking your bond.
Yes, Your Honor.
Thank you.
On the next case, I did not make an offer, but all of our out on bond cases have competency issues.
Thank you, counselor. Please tell me your name. Miss Blake. It's okay. I'm just telling you why you're here today, all right? Your case number is 21MM1401. You were arrested for trespass on property after warning. There is probable cause in this case. I'm going to appoint the public defender to represent you. Does the state object to an ROR in this case?
No, Your Honor.
Based on representations by counsel, ma'am, I'm going to release you on your own recognizance.
Thank you.
And I'm not going to revoke your bond on your out-on-bond cases. But ma'am,
Yes, ma'am.
you're not allowed to return to Graffiti Junction. Do you understand?
Yes, ma'am.
All right. Good luck, ma'am.
Thank you.
Yes, ma'am. Please tell me your name.
Theodore Colley.
Thank you, sir. All right, Mr. Colley, you're here in 21 MM 1406, charged with resisting an officer without violence in open container. There is probable cause. I'm appointing the public defender to represent you. Sir, I have a plea agreement form here. Did you sign this form?
Yes, ma'am.
And you're interested in taking the state's offer today, which is an adjudication of guilt, credit time served, and then a withhold?
I was looking at his second case. I didn't know because it was an open container. I don't know if it was a city ordinance.
Yeah, second case. Oh, no. Oh, no.
It's 2 counts.
Okay.
Yeah, yeah, same.
Okay,
So-
so it'll be adjudication. You're-
Okay, I'm going to scratch this out.
Okay, thank you.
So the state's offer is adjudication of guilt and credit time served plus court costs. Is that what you want to do here today?
Yes, ma'am.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can put your hand down now. Sir, you understand all the rights you're giving up by entering this plea?
Yes, ma'am.
You understand if you're on probation, this plea could violate that probation?
Yes, ma'am.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am.
All right. At this time, how do you wish to plead to the charges of resisting an officer without violence and open container?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for 1 day in jail, and I'll order you to pay court costs and give you a year to pay it.
Yes, ma'am.
Good luck, sir.
Thank you.
I'm going to appoint the PD on all of them. Because she had them do this, so. Please tell me your name.
Nazaré Raúl García Feliciano.
Thank you. In case number 202794, a warrant was issued for your arrest out of Seminole County. There's no bond on that warrant. We'll let Seminole County know that you're here. In 2011300976, a warrant was issued for your arrest out of Volusia County. It looks like a child support warrant. The purge amount on that is $370, and we'll also notify them that you're here on that charge.
I already paid it.
Okay, I don't have access to that information, but then we won't notify them that you're here on that. In 21 MM 1396AO, you're charged with resisting an officer without violence. There is probable cause. I'm appointing the public defender's office to represent you. I have a plea agreement form here. Did you sign this form?
Yes, ma'am.
So you want to take the state's offer of adjudication of guilt and credit time served?
Yes, ma'am.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you understand all the rights you're giving up by entering this plea? You understand if you're on probation, this plea could violate that probation?
Yes, ma'am.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am.
At this time, how do you wish to plead to the charge of resisting an officer without violence?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for 2 days. I'll order that you pay court costs, and I'll give you a year to pay it. Good luck, sir. Sorry. Please tell me your name.
Antoine Harrison.
You're here in case number 21 MM 1374AO, charged with trespass on property after warning.
And Judge, I did not commit offer for the same reasons. Previous, this defendant has competency hearing issues and hearings set on all cases, some in March, and the last one is in May.
All right, so I'm going to appoint the public defender to represent you. At this time, does the state object to an ROR?
No, Your Honor.
I'm going to release you on your own recognizance on this charge, sir, and I'm not going to revoke your other bonds, but you're not allowed to return to the Lynx bus station. Do you understand?
Yeah.
And you still have to come to court when you're ordered to do that. You understand?
Right.
So you need to stay in contact with your attorney, okay? All right, good luck, sir.
How you doing?
Good afternoon. Please tell me your name.
Nate Keaton.
Thank you, sir. You're here in 21 MM 1393AO, charged with trespass on property after warning. There is probable cause. I'm appointing the public defender's office to represent you. I have a plea agreement form in my hand. Did you read this form and sign it?
Yes.
You understand the rights you're giving up if you enter a plea today? Hold on, wait. Let me swear you in, and then I'll ask that question again, and you can ask any questions you have. Raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
Yes.
All right, did you have a question for me?
He does not want to accept the state's offer today.
Okay, you don't have to, sir.
All right.
All right, so then at this time, is your attorney entering a plea of not guilty?
Yes, Your Honor. Any objection to a ROR?
State?
One moment.
Yes.
No objection, Your Honor.
All right. At this time, I'll release you on your own recognizance. You're not allowed to return to the airport. Maintain contact with your attorney. Good luck.
Thank you. So I'm allowed to leave today?
Yes, however long it takes them to process you out.
Cool. Thank you so much. Can I sign this? Oh, okay. Thank you.
Please tell me your name.
Michael Knight.
You're here in 21 MM 1398AO, charged with retail petty theft. There is probable cause. I'll appoint the public defender's office to represent you.
Mr. Knight's case on the Allen bond, we made a decision on.
You have or have not?
Have not. It was an 11/23 arrest, and we still not made a charging decision. I'm not in intake, Your Honor.
November?
I'm not in intake, Your Honor. I'm here to be her seat.
All right. Your bond is $250. You're not allowed to return or have contact with the victim. Do you understand?
Yes.
As to your out on bond case, you're actually on pretrial release. I'm going to revoke that pretrial release. And make it a monetary bond of $1,000.
500 on each count?
Yes.
Okay.
So would it be 200 to get it out or 300?
Well, it's $500 on each count. What you have to pay a bondsman is between you and a bondsman. Good luck. Please tell me your name.
My name is Joseph Lars Lear, Your Honor.
Yeah, leave your mask on. Thank you. It's all right. It's hard to hear in here, but I still need you to leave your mask on for everyone's safety. You're here in 21 MM 1384AO, charged with trespass on property after warning. Does the state have an offer in this case? Did he sign a plea agreement? You know what? Do you want to put him up here and then she can tell me which ones? Can you do that, Miss George?
I only have one left, Your Honor.
Oh. We'll get this worked out eventually. Thank you so much. All right. All right, sir, I have a plea agreement here in my hand. Did you sign this?
Yes, I did, Your Honor.
All right, let me have you raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
Yes, I do.
All right, did you read this agreement, and do you understand the rights you're giving up by entering a plea today?
I do, Your Honor.
You understand that if you're on probation, this plea could violate that probation?
I do, Your Honor.
You understand if you're not a United States citizen, this plea could subject you to deportation?
I do, Your Honor.
At this time, how do you wish to plead to the charge of trespass on property after warning?
No contest, Your Honor.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for
2 days.
2 days in jail, order you to pay court costs. I'll give you a year to pay it, and that you're not allowed to return to the scene. And at this time, I will not revoke the bond in your out on bond case. Good luck.
And that means that I could get released today, Your Honor?
Yes.
Thank you, Your Honor.
Yes, sir. Right. I don't have his paperwork. Do you guys still have it? Thank you, ma'am. All right, this is case number 21 CF 2370. Tell me your name again, sir. All right. You're charged with domestic battery by strangulation. Ma'am, do you wish to testify today?
Yes.
Raise your right hand, please.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Caitlin Hutchins.
Does the state wish to inquire?
Yes, Ms. Hutchins, how do you know Mr. Roach?
We've been dating for 2.5 years.
You two live together?
Yes.
Are you afraid of him?
No.
Would you like for him to be allowed to have no hostile or non-violent contact with you while this case is pending?
I would love all contact with him.
Were drugs or alcohol related to this incident?
We were drinking.
If something happened in the future, would you feel comfortable in calling the police or 911?
Yes.
And do you still want to continue to live together?
Yes.
No further questions, Your Honor.
Does the defense wish to inquire?
No, Your Honor. No objection to leaving all conditions as is and modifying no hostile contact, Your Honor.
Do you have the order that I signed this? Thank you. Let me look what I said.
There was no contact, the pretrial release. maintains it.
Do you also live in Pennsylvania?
Yes.
All right, based on the testimony here today, I will allow you to have peaceful contact. Do you understand what peaceful contact means? It means you can't even raise your voice. So if he raises his voice at you, you call the police.
Okay.
It's a violation of his conditions of pretrial release.
Okay.
You understand that? All the other conditions will stay the same, and you're still not allowed to have any contact with the witnesses. Do you understand that? All right, thank you, sir. Thank you, ma'am, for coming. Good luck. I don't need that one again. All right, thank you. Please tell me your name.
Elijah Peterson.
You said Peterson, right?
Yes, ma'am.
All right, you're hearing case number 21MM117AW, charged with loitering or prowling. I'm going to appoint the public defender's office to represent you. Madam, do you wish to be heard at this time?
On bond, Your Honor.
Okay. There is probable cause. What do you want to say about bond, counselor?
Your Honor, in this case, the state was given an offer of a withhold of adjudication credit for time served, no return. However, my client wants to fight the issue in the trial division, so we would just ask for an ROR on this case. The facts in the arrest affidavit just states he was walking on the sidewalk on his way home, and because of that, and the fact that he is doing pretrial, he's supposed to start pretrial diversion on the attempted burglary of a conveyance, we would ask for an ROR.
What says the state?
No objection, Your Honor. That out-on-bond case has the status hearing to see if he has finished the prior to pretrial in May. May 20th.
All right, sir, at this time, I'm going to release you on your own recognizance. You're not allowed to have contact with any of the witnesses in this case. Do you understand what that means? You have to answer out loud.
Yes, ma'am.
And do you live near Fowler's Grove?
No, ma'am.
All right, then I'm going to order that you're not allowed to return there. Do you understand?
Yes, ma'am.
All right, good luck. I'm taking no action on the out-on-bond case. have Jerry Pollard bonded. Please tell me your name.
Andre Solomon.
You're here in 21 MM 1405 AO, charged with indecent exposure. You said Andre Solomon, right?
Yep.
All right, there is probable cause. I'm appointing the public defender's office to represent you. Your bond is $500.
Well, I think that's the last offer, the plea form, Your Honor.
Thank you. How many days credit does he have?
One.
I don't know that I'm inclined to accept that. I need to hear from the parties why that's the offer.
The original witness that witnessed it left prior to law enforcement ever making contact with that person. Then you just have law enforcement.
All right. All right, sir, raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
All right, you can put your hand down. I have a plea agreement form in my hand. Did you read this form and did you sign it?
Yes.
Do you understand the rights you're giving up by entering a plea today?
Yep.
You understand that if you're on probation, this plea could violate that probation?
Yep.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes.
At this time, how do you wish to plead to the charge of indecent exposure?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the
1 day.
1 day that you've been in jail. I'll order that you're not allowed to return to the scene. You're not allowed to have any contact with any witnesses. And I'll give you a year to pay your court costs. Good luck. Case number 21MM1370. Yes.
Historic case, the state's gonna file it.
Oh, the state's dropping the case?
State is, Your Honor.
All right.
And Mr. Vargas' case, while we're up.
All right, so that's case number 21MM1395. Is this Mr. Vargas?
Yes, Your Honor.
The state is filing an announcement of no information in your case. And I'm not going to take any action on your out-of-bond cases. So you'll be released. Good luck, sir. Please tell me your name.
Alex Jerez.
Counselor, if you'd like to announce your appearance for the record.
Thank you, Your Honor. Jonathan Rose, excuse me, on behalf of Alex Jerez.
This is case number 21 CF 22850. Sir, your charge was sexual battery on a person over 18. 4 counts. A warrant was issued for your arrest. So another judge already found probable cause. Counselor, I assume you want to be heard as to bond?
That's correct, Judge.
Go ahead.
May I take some brief testimony from Mr. Jerez in order to establish the 903-046 factors?
Can you say that once again really close to the microphone? Just move that mic over by you. You have to leave your mask on, I'm sorry.
No, it's fine.
But if you just get closer, it's easier for me
Yes,
to hear.
ma'am. I just wanted to take some brief testimony from him about the 903-046 factors for the court's edification.
Yes, sir.
Thank you.
Please proceed.
Please state your full name for the record.
Alex
Oh,
Jerez.
we need him sworn in. Yeah.
Sorry.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your full name for the record.
Alex Jerez.
Mr. Jerez, where do you live?
Winter Park, Florida.
How long have you lived in Winter Park, Florida?
A little bit over 3 years.
How long have you lived in the Central Florida area?
Since 2008.
Where did you live before that?
Lake Nona, Eagle Creek.
And how long did you live there?
5 years.
How long have you lived in Florida?
Oh, Florida, I've lived here since 2008. Originally, I lived here since 95, went to college up north in 2000, moved back down in 2008.
Okay. And how much of your family lives in this Central Florida area, so Metro Orlando?
My entire immediate family lives here. My parents, my 2 sisters, my nephews, Also, I have my 2 boys that live with me 50% of the times in my co-parenting plan,
How old are your children?
8 and 10.
Tell me about your involvement with your children.
My sons are 8 and 10, and we usually play, well, pre-COVID, we usually play football 3 seasons out of the 4. We take the summers off so we could do summer vacations. I've been coaching their teams for 5-6 years now at the YMCA at Lake Nona. I know all the parents there. At the end of every season, the parents always come up to me and want to know when I'm going to coach again so that their son or daughter can be on the team with one of my 2 boys. I'm very involved with the community.
Do you have any other civic involvement other than coaching your sons?
Well, as far as my job is concerned, I do. I help people that get into automobile accidents. So I actually help get them rehabilitation in the process after their auto accident.
And tell the judge about the company that you're referring to and also your work as a realtor.
Right. So the company is Injury Medical Solutions, and I've been doing that since 2008. And from then to now, it's 13 years or so. I've helped somewhere over 1,500 people in their recovery to becoming better. I've also had my real estate license since 2012, and I have my real estate company, We Help Realty LLC, since 2012. And I've helped a few hundred people accomplish their dreams of owning a home through, excuse me, Your Honor, through helping people, treating them the way that I would want to be treated and giving them the best possible advice.
And are you in generally good health?
Yes, sir.
Are you under the care of a psychiatrist or psychologist for any sort of diagnosed mental illness?
No, sir.
Have you ever failed to appear for a court hearing?
No, sir.
That's all I've got with respect to 903-046 factors. The only thing I would have some brief argument about the strength of the evidence.
State of Florida.
I have no questions for the defendant.
All right. Counselor, you can proceed with your argument. Just get really close to the microphone.
Sorry. Thank you, Judge.
This is really loud up here, so it's impairing my ability to hear you, but when you're close, it's easy.
The masks are a challenge, but thank you very much, Judge.
Yes, they are.
Judge, briefly, obviously, one of the things that the court has to take into consideration is the strength of the evidence. And I would note that everything contained in this is merely what the alleged victim says. There is no mention whatsoever of any sort of physical evidence in this affidavit. I have, for the court, should the court want to consider, I understand this is a bit unorthodox at this point, but he did undergo a polygraph examination yesterday with an individual named James Orr, who's a retired FBI polygrapher. And I have a copy for the court and the state should want to consider it. But I will tell you that he was considered to be not deceptive. Given the 3 factors, if the court is interested in it, then I can certainly provide you and the state with that report. With respect to any other factors, I would note that the affidavit mentions some previous arrests. And I would also note that 903-046 states specifically that the court should consider previous convictions, which would seem to imply specifically that a previous arrest for which there were not convictions should not be considered by the court. And again, I do have a copy of the polygraph and Mr. Orr's CV should the court wish to see it.
Well, it's your case, counselor, so if you want to enter those, I'm happy to review it. If you don't, it's
Yes, ma'am.
up to you. Thank you, sir.
Just to make it a little bit more efficient for the court, the relevant questions that were asked by the polygrapher are on page 4. or three that he defines as relevant questions, and then the determination of lack of evasiveness is on page 7.
Thank you.
It's a bit lengthy, so.
I'm sorry?
It's a bit lengthy, so I just wanted.
It is. I was on page 4. I wasn't intending to read the entire thing right this moment.
No, ma'am, of course not. I appreciate the court's consideration.
All right, does the state have any argument?
Your Honor, this is not a PBL, so the defendant is entitled to a bond. Your Honor, based on the nature of the relationship between the defendant and the victim, and how that she did, based on what your statement is in the application for affidavit or arrest warrant, that based on the friendship, she asked him for help or comfort when she was trying to seek a divorce, and allegations are to take advantage of that situation. We would request a high bond. I understand the defendant has, I think in my system, I just see a conviction for driving. I don't see, 2005, I'm not saying, for driving DUI, 2005, excuse me.
That's correct.
But I don't see any other prior convictions. I do see other arrests. As defense counsel has stated, we would just ask for no contact with the victim, maintain, several residences, no weapons, no firearms, no drugs, no alcohol. I understand that, the defendant states that he coaches football and that's, great, but we would ask for no contact with any minor children except for his children during the, pendency of this particular case.
All
May I
right.
be heard briefly, Judge?
Yes.
With respect to all the conditions, I don't have any objection to the conditions as suggested by the state, with the exception of minor children. There's absolutely nothing in his history or about this case that suggests that he is inappropriate to be around minor children. He has 2 school-age children. He is responsible for them half the time. He's involved in their lives. That means that that's going to make it more difficult for him. And if I'm not mistaken, his wife has COVID currently. So I think that it would be tenuous and put the family in a bad position to make that kind of restriction, given that there is absolutely nothing about this case or its history that would suggest that that is an issue. With respect to the bond amount, we would request a $25,000 bond, which I think reflects the seriousness of the allegations, yet also reflects that there are a number of very clearly unresolved issues.
What says the state as to that amount?
It's fine with the bond, Your Honor. However, we understand that his position, the defense's position on minor children. The problem is, if the defendant was convicted and became having to register as a sex offender, that condition would be something that he's going to do. So we just think at this time, it's no reason to take the unnecessary risk to have him. And I understand it may be inconvenient, but being in court jurisdiction is inconvenient.
All right, thank you both for your arguments. At this time, sir, your bond is going to be $25,000 on count 1, $100 on count 2, $100 on count 3, $100 on count 4. You're not allowed to have any contact with the victim. Do you know what no contact means?
Yes, ma'am.
You can't call her on the phone. You can't speak to her using some kind of social media app. You can't send a message through friends. No contact at all. You understand?
No problem, Your Honor. I have no interest.
All right, you're not allowed to possess a weapon of any kind, a firearm or ammunition.
Yes, ma'am.
And at this time, I will order that you are allowed to have contact with your minor children, but no other minor children. Counselor, I understand your argument, but I think you need to file a motion in front of the trial judge for that, because I do think, based on the state's arguments at this time, I'm persuaded by that. So,
And Judge, I believe the counts 2 through 4 should be 150 as their felonies.
I'm sorry, you're right, it's 150. Thank you, Counselor. I'm treating them as subsidiaries.
Understood. Thank you.
Are there any other conditions the state would request?
No, Your Honor.
All right, thank you. Thank you for your time,
Your Honor,
Counselor.
have a great weekend.
Good luck, sir. All right. All right, that's case number 21 CF 2355AO. Possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, and possession of a motor vehicle with an altered serial number. I'm going to appoint the public defender's office.
We'll waive, Your Honor.
Does the state wish to be heard as to bond?
No, Your
It'll be $5,000 on count 1, $150 on count 2, $150 on count 3. He's not allowed to possess a weapon of any kind, firearm, or ammunition. Please tell me your name.
Antoine Latrell Atkins.
You're here because a capias was issued for your arrest in case number 20 CF 10862. The charge is grand theft of a motor vehicle, and it's alleged that you failed to appear for a status hearing. The capias has a bond of $1,000. I'll appoint the public defender's office to represent you. Good luck, sir. Yes, sir.
They never sent me no court papers.
I can't change a capias that was signed by another judge, so your attorney can file a motion in front of that judge. All right, good luck, sir. Please tell me your name.
Marquez Atkins.
You're here in case number 20 CF 14053AO. A warrant was issued for your arrest for trafficking in methamphetamine, 14 grams or over, possession of a weapon or ammunition by a convicted felon, grand theft of a firearm, possession of methamphetamine, possession of cocaine, and possession of cannabis over 20 grams. On count 1, your bond is none. Count 2, it's $5,000. Count 3, $1,000. Count 4, $1,000. Count 5, $1,000. Count 6, $100. You're not allowed to possess a weapon or firearm, ammunition, or any illegal substances, and you're not allowed to return. And you're not allowed to have any contact with any witnesses in the case. In case number, sorry, go ahead.
I'm sorry, this was on the trafficking, or was the fair to appear?
That was the trafficking.
Oh, yeah. He's entitled to a bond, Your Honor.
Oh, does the state wish to be heard as to bond?
No, Your Honor. We don't have to continue on the amount.
All right, it'll be $50,000 on count 1. I'm leaving the other counts as is. In 2018 CF 7855AO, a capias was issued for your arrest for failing to appear for a trial management conference on a charge of possession of a firearm by a convicted felon. Your bond on that is none. I'll appoint the public defender's office to represent you in that one as well. Good luck, sir.
I have a lawyer.
Oh, you have a lawyer?
I'm trying to figure, I'm supposed to have court today. Can you see if I'm supposed to have a motion to suppress hearing today on that case?
I don't know about that, sir. Who's your attorney?
Benjamin Jones.
All right, then I'm not appointing the public defender's office to represent him. Sorry, change that. What?
It was set by 223 by Judge O'Kane.
It's set when?
Set like 223.
Okay. So you'll have to contact your attorney, sir, to find out about that.
And then maybe what if failure to appear came in.
Okay. Good luck. Please tell me your name.
Ravindranath Dejnath.
You're here in case number 20 CF 12754. A capias was issued for your arrest for attempted manslaughter by act with a weapon. There's a $10,000 bond on that capias. You're not allowed to have any contact with the victim, any co-defendants, or any witnesses in the case. You're not allowed to return to the scene. You're not allowed to possess or consume any alcohol, illegal drugs, or controlled substances without a valid prescription. And you're not allowed to possess a weapon of any kind, a firearm or ammunition. And I'm appointing the public defender's office to represent you. Good luck. Please tell me your name.
Darius Blair.
You're here in 21 CF 2335AO. It's not a warrant, sorry. You're charged with burglary of an unoccupied dwelling, grand theft, third degree, and criminal mischief. I'm going to appoint the public defender's office to represent you. I reviewed the probable cause affidavit. There is probable cause in this case. Your bond on count 1 is $5,000. Count 2 and 3, $150. You're not allowed to return to this scene. You're not allowed to have contact with the victim or any of the co-defendants in the case. Do you understand what no contact means?
Yeah.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir.
Your Honor, Brennan, he refused court.
All right, he has several cases, Counselor. I'm going to appoint the Public Defender's Office. Okay, so let's start with the out-of-county warrants. 1903261 is out of Osceola County. It's a violation of probation. There's no bond, so I am going to appoint your office. In 21 CT 1539, there is probable cause. I'll appoint your office. His bond is $100. In 21 MM 1367, his bond is $100. I'll appoint your office to represent him. There is probable cause in that case as well. And then in 21 CF 2312AO, there is probable cause. His bond is $1,000, no victim contact. And I'll appoint the Public Defender's Office. And I find his refusal to come to court a willing waiver. All right, a warrant was issued for his arrest in 21 CF 9950 for possession of cocaine and drug paraphernalia. The bond is $1,500 on count 1, $500 on count 2. I'll appoint the Public Defender's Office. In 21 CF 2323, possession of cocaine, there is probable cause. I'll appoint the Public Defender's Office to represent him. His bond is $1,000. And I'm revoking on the out on bond case, 20 CF 11969. It's the same charge, Counselor. Please tell me your name.
James M. Christian.
You're here in 21 CF 2310 AO, charged with possession of a firearm by a convicted felon, grand theft of a motor vehicle, possession of drug paraphernalia, and possession of methamphetamine. I'm appointing the Public Defender's Office to represent you. There is probable cause in this case. I reviewed the probable cause affidavit. I'll leave your bond at $8,000 on count 1, $150 on count 2, $100 on count 3, $150 on count 4. You're not allowed to have contact with the victim. You're not allowed to possess a firearm or weapon of any kind or ammunition. You understand that?
Yeah.
And I'll order that you're not allowed to possess or consume any illegal substances. Good luck, sir.
All right, thank you.
Please tell me your name.
Timothy Clark.
In case number 21MM1110, a warrant was issued for your arrest for battery and criminal mischief. Your bond is $1,000 on count 1, $1,000 on count 2. You're not allowed to have any contact with the victim, and you're not allowed to possess a weapon of any kind, a firearm, or ammunition. Do you understand that?
Can I speak? Who is the victim?
One moment, I'll tell you that. If the state can find it faster than I can, please. All right, that's who you're not allowed to have any contact with. Can you say your name one more time?
Gretty, his first name, last name is Henry-Red.
That's who you're not allowed to have any contact with.
I don't even know that person.
Then no contact should be easy.
Okay, Your Honor, can I speak also? Ma'am,
So just a second, let me tell you something. I'm going to appoint the public defender to represent you. The only thing we're doing here today is I'm advising you what the charges are and what your bond amounts are and your bond conditions.
I'm going to ask them if I can find mercy on behalf of the court. Ma'am, my house just burnt down on the 14th. I lost everything.
I'm really sorry about that, sir.
Just to let you know, in the out of bond cases, the competency hearing is set for March 5th.
All right, then I'll take no action on those cases. But as to case number 21 CF 2354, possession of MDMA, I'm going to appoint the Public Defender's Office to represent you. There is probable cause in that case as well. All right, sir, I'll make your bond $500 in that case. Talk to your attorney about your cases, okay? Good luck, sir. Please tell me your name.
Leon Cooper.
Hold on one second. Yes, each $1,000. Sorry, tell me your name once more.
Leon Cooper.
In case number 21 CF 2281, a warrant was issued for your arrest for fleeing or attempting to elude law enforcement. I'm appointing the Public Defender's Office to represent you. Does the state wish to be heard as to bond?
No objection to PTR.
I'm not inclined to place him on pretrial release. Why? Why is the state saying that?
Let's see, he has 1 felony, 5 misdemeanors, a failure to appear from over 15 years ago, and he qualifies.
Can the attorneys approach for a moment? All right, thank you for your patience.
Oh, Your Honor, he has a private attorney.
Oh, he has a private attorney? Then I'm not appointing the Public Defender's Office. Yes, sir.
Oh, that's what I was just gonna tell you.
What's your attorney's name?
Allison Cressy.
Who?
Allison Cresty.
Allison. I couldn't hear that. Can someone tell me if she's entered a notice of appearance in this case? Does the clerk have that?
She.
And have 1 moment to send a text message, Your Honor.
Yes, please. Oh, she did? All right.
Said she's outside. I think she made her way in.
Outside here? All right, can we bring him back, please?
She's still texting, so she just says I'm
Okay.
outside. Can I come in now? Yes.
Yes?
I will say yes.
All right, please tell me your name, sir.
Michael DeGrossa.
In case number 21MM 13267, a warrant was issued for your arrest out of Brevard County for trespass in a structure or conveyance. The bond is $1,000. We'll notify them that you're here. In case number 21 CF 2318AO, you're charged with burglary of a conveyance, disorderly intoxication, trespass on property after warning, and resisting an officer without violence. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Your bond will be $3,500 on count 1, $100 on count 2, 3, and 4 each. You're not allowed to return to the scene. You're not allowed to have contact with the victim or witnesses or co-defendants. Do you understand?
Yes.
Are there any other conditions the state would request?
No, ma'am.
All right, good luck. Please tell me your name.
Alonzo Green.
In case number 2015 CF 16644AO, a capias was issued for your arrest for grand theft. The bond amount is $2,000. And I'll appoint the public defender's office to represent you. Good luck. Please tell me your name.
Tamir Hurston.
In case number 21 CF 1626, a warrant was issued for your arrest for failing to report or check in within 30 days on sex offender probation. Your bond on that is $5,000. You are still required to register and report as required by law. You understand, sir? You still have those reporting requirements.
Yes, ma'am.
In case number 21 CF 2311AO, possession of MDMA, I'll appoint the public defender's office to represent you. There is probable cause. Does the state object to me treating that as a subsidiary with a $150 bond?
No, Your Honor.
All right, your bond will be $150. You're not allowed to possess or consume any illegal substances. Do you understand? Or have contact with known drug dealers? You understand, sir? All right, good luck. Please tell me your name.
Jeff Hoover.
In case number 21 CF 2341, you're charged with burglary of a structure and grand theft. I'm appointing the public defender's office to represent you. There is probable cause in this case. Your bond is $3,500 on count 1, $150 on count 2. You're not allowed to return to the scene, have contact with the victim, or any witnesses or co-defendants. Do you understand?
Yes.
Does the state have any thoughts on his out on bond cases?
They're all set for 4:30 for a status. I'm assuming that's going to get his driver's license.
Yeah.
But they've been all set that far out, so no objection, no action.
Yes, Your Honor. The last note on January 4th states he's currently in the process of getting his driver's license. So we would just ask for no action.
I know the clerk's office had Project Greenlight this week. Can't remember which one, and a lot of people are trying to get their license this week.
All right, I'll take no action on those cases. Good luck, sir. Deandra Jackson. Please tell me your name. Oh, wait. What's your name, sir?
DeAndre Jackson.
21 CF 2348AO. You're charged with possession of methamphetamine, possession of drug paraphernalia, trespass on property after warning, and possession of cannabis under 20 grams. I'm going to appoint the public defender's office to represent you.
No objection, ROR counts 2 and 4, Your Honor.
There is probable cause. Your bond will be $1,000 on count 1. On which counts, counselor?
2 and 4, we're not going to file them no matter what, so.
But 3, we are.
Yes.
All right. So count 2, I'll release you on your own recognizance. Count 3, your bond will be $100. Count 4, I'll release you on your own recognizance. You're not allowed to return to this scene. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. As to his out on bond case, 20 CF 14238, it's a felony petty theft, counselor.
There's no objection, no action.
At this time, I'll take no action on that case, sir. Good luck.
Thank you.
Is this more? Please tell me your name.
Charity Kemp.
In case number 21 CF 2290, a warrant was issued for your arrest for aggravated battery, aggravated assault, robbery by sudden snatching, burglary to a conveyance with a battery therein, and petty theft.
She has a private attorney, Your Honor.
Okay. What's your attorney's name?
Joseph Silwick. He's with Mandel Law. I have his phone number.
I do not have that attorney's number. I don't know who that is.
Shouldn't they know? No?
I told him yesterday I have court today.
It also could be Ms. Christie thought we were starting court at 1 o'clock, so it could be
Oh,
that if they think that,
right, if they think we're starting at 1 and we start earlier, they wouldn't know.
yeah, she was in her car. I thought she was having to be here, right, in the text, so. I'm gonna pass that case for.
Yeah, can we pass her case for, is that okay?
Yes.
Sorry. I don't want to make it hard on you guys back there.
Is she writing the number down? Yes, you can call, see if.
Joseph.
Thank you. Thank you, Dexter. Counselor, if you want to put your appearance on the record.
Allison Carestes for Leon Cooper.
This is case number 21 CF 2281. A warrant was issued for his arrest for fleeing or attempting to elude law enforcement. Do you wish to be heard as to bond, Counselor?
Your Honor, I did speak with Ms. Kennedy Swanson. She indicated the court was thinking about putting pretrial release conditions. I would ask that you just set a straight bond and not impose pretrial release.
At this time, based on his record and the facts in the affidavit, I'm not inclined to do that.
Understood, Your Honor.
Your bond is going to be $2,000, and I'm also placing you on pretrial release.
Mr. Cooper has indicated that he does have a medical marijuana card. Will that cause an issue with pretrial release?
I don't know how. Yes, they will drug test him, but I don't know how that works if they have a medical marijuana card.
Yeah, I don't know how that works.
He shouldn't be violated, because it would be a criminal charge. He shouldn't be violated.
If he has the card.
I would say, if Your Honor, in her order, that as long as he shows proof of his card to pretrial services, they won't violate him for marijuana.
Thank you.
All right, that's what I'll say in my order then. I would imagine it's now the same as other drugs. As long as he has a valid prescription, that won't violate his conditions of pretrial release.
Understood.
But any other substance will, because he'll be subjected to random screens. Are there any other conditions the state would request?
I'm sorry, Your Honor, I did not hear the bond amount.
$10,000
Plus pretrial, thank you.
plus pretrial release, yes.
Is it 10,000?
10,000. No, I said 10. I wrote it right there. See, it's the masks and this thing. You can't hear up here. It's $10,000 plus pretrial release, and you're not allowed to possess or consume any illegal substances. As we just discussed, if you have a valid prescription, you'll have to present that to pretrial release. Do you understand?
Thank you, Judge.
All right, good luck. Thank you, Counselor. This is Judge Gibson.
This is Judge Wick.
Good afternoon, Counselor. We're here in open court, and I have Charity Kemp. Is that right, ma'am? Does your office represent her?
Yes, Your Honor. I'm not sure if the notice has been received yet, but we do represent Ms. Kemp.
All right. This is 21 CF 2290. Ma'am, a warrant was issued for your arrest for aggravated battery, aggravated assault, robbery by sudden snatching, burglary to a conveyance with a battery therein, and petty theft. That means another judge has already found probable cause. The bond amounts contained in the warrant, I will maintain. It's $1,500 on count 1, $1,000 on count 2, $1,000 on count 3, 0 on count 4, and $100 on count 5. You're not allowed to have contact with the victim. You're not allowed to return to the scene. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
Are there any other conditions?
I'd like to be heard on the no bond for the burglary dwelling.
Yes, sir.
Based on the affidavit, Your Honor, I don't believe that the proof of guilt being evident and the presumption being great would be met on this. I'm new to the case, but I've already received a phone call from...
Hold on one moment, Counselor. Counselor, I can't actually hear you. Can you get closer to your phone?
Yes. Is this any better? I'm getting an echo on my end.
I don't hear the echo, but this is a little bit better. I just turned the volume way up in the courtroom. If you can say all of that again, I apologize.
Okay. I'd like to be heard regarding the no bond on burglary of a dwelling charge. I don't believe that the burden of the proof of guilt being evident and the presumption being great is met under the facts of this case. I've already received a phone call from a eyewitness in the case that indicates that this is a really blown out of proportion. Ms. Kemp has no criminal record at all. I represent her on her 2 other open cases that she was out on notices to appear on those. But other than that, she has no criminal convictions, and I believe the allegation in this case is that she essentially reached into a vehicle, but this is not a burglary of a dwelling, but assault or battery that I expect would be a no-bond case.
So I believe it's, let me turn this back down. I believe it's charged as a burglary of a conveyance with a battery. Is that not, perhaps the state can remind the court
Correct.
what level felony that is?
I think it's a light felony, but it's basically like, based on what I read the affidavit, is the allegation is she reached into a car. But the person in that car, got out and started fighting with my client. So I believe that, once we have an opportunity to conduct discovery, this will be
He's saying that
much different than the charges.
the allegations are that the person that this defendant threw a rock, according to the police report, at the victim in the car, and then the defense argument is that victim gets out of the car and they have a fight. Unlike somebody breaking into a stranger's house or randomness or whatever. Sorry, attorney, you were breaking up a little bit.
Right, thank you, Counselor. I'm sorry, the phone is really breaking up, but the state was trying to help the court understand what your argument is. What
So I'm
says
just
the
asking the
state?
court to set a bond on that count.
State's request is that she is not entitled to a bond on count 3.
Yeah, Counselor, I understand your argument. I think that's an argument that you have to make in front of the trial judge, because at this time, she's not entitled to a bond, and I'm not moved to set one. So I'm going to leave it
Your
at...
Honor, I respectfully disagree that the bond on a warrant, it has to be a no bond until you see a first appearance judge. And then the only people that have the power to change that are the first appearance judge or the judge in the business in front of. And
Right, I'm not saying the court doesn't have the
you-
power. I'm saying I'm not inclined to do it.
So you have to find that you believe that based on the allegations, the proof of guilt is evident and the presumption is great. And I don't believe that there's any evidence of that in that affidavit.
So if you're asking the court to hold an Arthur hearing today and find that the proof is evident and the presumption is great, I will ask the state if they're ready to go forward on that hearing, and we can do that hearing today. But my understanding of the law is, if we do that today, you can't then do it again downtown in front of the trial judge.
Correct, that is the state's understanding. So if that is defense, and obviously defense is not present in court. So
Right, he'd have to come here.
Even if I show the court something, then the defense isn't here, and so we would then object to any kind of Arthur hearing being held downtown in Division 19.
Well, if the court's not going to set a bond based on this situation, which I think the state really should be embarrassed to try to say that this is a no bond case and seek a pretrial detention, then I will reserve argument and set this in the courthouse as soon as possible if we can deal with it there.
He said
He said he's going to preserve the argument, is that right?
yes, and said it.
Correct.
All right. I'm sorry, Counselor, for the problems with the electronics. I just want to make sure that the record is clear and that I'm understanding what you're saying.
Just for the record, Your Honor, I think I would say that the defense counsel should be very careful when he's asking the state whether they are embarrassed to go forward on any arguments or not. I think that's a bad choice of words for this defense counsel to use. So be mindful of language.
I will note that very seriously.
Thank you, sir.
All right, thank you both. And at this time, I'm leaving the bonds, like I said, as is. There's no contact with the victim and not return to the scene. Do you understand, ma'am?
Now, my baby's in a hospital. Can I just please get a bond? My baby's having surgery on Tuesday.
Ma'am, I'm not going to change that at this time because of it's charged as a first-degree felony punishable by life in prison. So at this time, this court is not going to give you bond on that count. But your attorney is on the line, I'm sure that you heard him, and he said that he's going to file a motion in front of the trial judge, and I'm sure he'll try to get that heard in the next couple of days.
That's
That
correct.
judge can change it. All right, thank you, Counselor.
Any action on the
Thank you.
bond, Your Honor?
Oh, wait, don't leave yet. Don't hang up, Counselor.
She's on notices to appear.
No, I'll take no action on that. All right, good luck, ma'am. Thank you, Counselor.
Thank you.
Please tell me your name.
Robert Menendez.
In case number 21CF2345, you're charged with possession of cocaine and possession of drug paraphernalia. I'll appoint the public defender's office to represent you. There is probable cause. Your bond is $1,000 on count 1, $100 on count 2. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. I show that he's on state probation and is a violent felony offender of special concern. Do you have that information as well?
I see the note on the,
Yes, Your Honor, that's correct.
I can turn that down now.
do we know if probation has done an on-view violation?
BOP is to be completed by his probation officer.
All right. Then I'll wait for that. All right, good luck, sir. Please tell me your name.
Aileen Moore.
Ms. Moore, a warrant was issued for your arrest in case number 21CF23240, charging you with first-degree murder with a firearm and home invasion robbery with a firearm and a mask. There's no bond authorized at this time. I'll not change that. But I will order that you're not allowed to have contact with the victim's family, with the co-defendants or any witnesses in this case, even while you're in custody. Do you understand?
Yes.
Are there any other conditions?
No, Your Honor.
All right. Did I appoint the public defender's office?
No, Your Honor.
I am appointing the public defender's office to represent you. Good luck, ma'am. David Munoz, bonded. What's your name, sir?
Clifford Petro, Your Honor.
In case number 21CF2346, you're charged with possession of fentanyl and possession of drug paraphernalia. I'm appointing the public defender's office to represent you. There is probable cause. Your bond is $1,000 on count 1, $100 on count 2. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Good luck. Oh. That's case number 21CF23280. Counselor, it's a warrant, burglary of a structure while wearing a mask and petty theft. Bond is $3,500 and $1,500. No contact with the victim, possess no weapons or firearms, not return to the scene. I'll appoint the public defender's office to represent him.
Thank you, Your Honor.
Sir, please tell me your name.
Yes, ma'am. I'm Robert Lee Pringle.
All right, in case number 21 CF 23661AO, you're here charged with driving while license suspended as a habitual traffic offender. I'm going to appoint the public defender's office to represent you, sir. There is probable cause in this case.
Yes, ma'am.
Your bond is $2,500. You're not allowed to drive without a valid license. You understand that, right?
Yes, ma'am. Sorry, it was a situation.
I'm not asking you to say anything about your case. Listen, everything you say is being recorded. I just want to make sure you understand what I'm telling you.
Yes, ma'am.
And on the out on bonds, we've not made a discharging decision. So no objection, no action.
All right, at this time, I'm going to take no action on your out on bond case. So I'm not revoking your bond.
Thank you, ma'am.
Your Honor, how much did you set the bond for? I didn't.
It's $2,500.
Okay, thank you, Your Honor.
Thank you. God bless.
Good luck, sir. Okay. Yes, sir. Please tell me your name.
Kevin David Speakman.
You're here in case number 21 CF 233-1AO, charged with grand theft. It's a second-degree felony, $20,000 or more, and burglary of a structure while wearing a mask. I'm going to appoint the public defender's office to represent you. There is probable cause in this case, sir. What says the state has to bond?
We'll leave that at the court's discretion. We have no objection, no action on the out on bond. Yes, hearing next week.
All right. On count 1, your bond will be $150. On count 2, your bond will be $10,000. You're not allowed to return to the scene. You're not allowed to have contact with the victim or any co-defendants in the case or any witnesses. Do you understand?
Ma'am.
Are there any other conditions the state would request?
No, Your Honor.
I'm going to order that you're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. However, I will not revoke on the out on bond case.
Thank you, ma'am.
Good luck. Stuckey bonded out?
Yes, he did, Your Honor.
Please tell me your name.
Kevin Steplight, Your Honor.
All right, you're here in case number 21 CF 2079. A warrant was issued for your arrest for home invasion robbery with a firearm, attempted first-degree murder with a firearm, discharging it with injuries, aggravated battery with a firearm, discharge, burglary of a dwelling with a battery with a firearm, and grand theft of greater than $100,000 from a dwelling. At this time, you'll be held at no bond on counts 1, 2, 3, and 4, $2,500 on count 5. Even while you're in custody, you're not allowed to have any contact with the victim or the co-defendants. Do you understand?
Yes, ma'am.
You're not allowed to return to the scene, and you're not allowed to possess a weapon of any kind, firearm, or ammunition.
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
Did I appoint the public defender?
didn't
I
hear
am.
you.
I am appointing you.
Thank you, Your
Good
Honor.
luck, sir.
Thank you so much, Your Honor.
Please tell me your name.
Jaquita Tarver.
In case number 21MO260, you're charged with disorderly conduct. I'm going to appoint the public defender's office to represent you. There is probable cause in that case. Your bond is $250. In case number 21 CF 2326, you're charged with possession of cocaine and resisting without violence. I'm going to appoint the public defender's office to represent you in that case as well. There is probable cause. Your bond is $1,000 on count 1, $100 on count 2. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
In case number 2019 CF 7678BO, you're out on bond for a grand theft from a designated construction site. I understand the state has no objection. Does the defense have a reason the court shouldn't revoke her bond?
Your Honor, the new charges she picked up are nonviolent, and it is a disorderly conduct city ordinance case, which we would resolve. And her last offense was in 2006 for petty theft. So nonviolent crimes.
All right, I'll take no action in this case at that time. Good luck, ma'am.
Thank you so much.
Thank you, counselor. Please tell me your name.
Juan Taylor.
You're here in case number 21 CF 2353AO, charged with possession of cocaine. I'm appointing the public defender's office to represent you. There is probable cause in this case. Your bond is $1,000. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
All right. As to case number 2019 CF 9737, he's out on bond for possession of cocaine. What says the state?
This is trial management on 311, no objection, no action.
Can the defense give the court a reason not to revoke his bond when he's out on bond and gets arrested for the exact same charge?
Yes, Your Honor, it may be a drug issue. However, he didn't pick up another violent offense. And normally they will resolve these possession of cocaine and the drug paraphernalia charges. So we would just ask that no action, or in the alternative, Your Honor, just set a new bond.
I'm going to take no action on that case, sir. Good luck. Please tell me your name.
Shane Wilson.
You're here in case number 21 CF 2357AO, charged with driving while license suspended as a habitual traffic offender. I'm going to appoint the public defender's office to represent you. There is probable cause in this case.
What is it?
I'm sorry?
What was the probable cause?
You were driving and your license was suspended?
Oh, okay, just,
That's the charge.
okay. Is there any way we can settle it right now?
No, sir, this is a felony, so we can't resolve that today. Your bond is $2,500. You can't drive without a valid driver's license. You understand that?
Yes, ma'am.
All right, good luck, sir.
Thank you.
Do we have Mr. Reddick?
He's still in courtroom with 2 heavy points.
Oh, sure.
Child
All right, so we'll be in recess for a few minutes.